all the time.
Okay. All right, we're about to call the meeting to order. If anyone has their cell phone, please silence it or turn it off or do whatever you do to not interrupt us. Public hearing before the Sawyer County Board of Appeals is hereby called to order at 6:30 p.m. April 26th at the Sawyer County Courthouse in Hayward. Present on behalf of the board, Al Gerber, Gordy Christians, Dee Doblis, Jim Kelsey, Jim Tiffany, and Steve Kelsey. Present on behalf of the board, Kathy Marks and Pat Brown. Statement of board hearing procedures. Those persons desiring to give pertinent testimony will be afforded the opportunity to do so. All, as recognized by the chairman, that person will clearly identify their full name before giving testimony. Each hearing will follow this order: reading of the application, submission of the file to the board, applicant statement and presentation of evidence, testimony of those in support of the application, statements from persons in objection to the application, rebuttal as permitted by the board, and decision by the board. Orderly procedure requires that each side shall proceed without interruption by the other. All testimony will be addressed to the board, and there will be no questions or arguments between individuals. Any persons aggrieved by a decision of the board may appeal the decision to the circuit court within 30 days of the date following the board's decision letter. The day following the signing of the board's decision letter is the first day of the 30-day appeal filing period. This public hearing has been published as a Class 2 notice in accordance with Wisconsin Chapter 985, Wisconsin statutes, and the Sawyer County Record and Sawyer County Gazette. The public hearing will follow this order: variance application, new business, and adjournment. What's that? Okay. Has the board members had an opportunity to review the minutes of our December 14th, 2021 minutes? And if so, is there a motion to approve those minutes? I read the minutes and I make a motion to approve them as presented. Seconded by Steve Kelsey. Any discussion on the motion? Okay, all those in favor of the motion, signify by saying aye. Aye. All opposed, same sign. Motion to approve the minutes passes by a vote of 5-0.
Mr. Chairman, tonight we have one appeals case, public hearing in the town of Hunter, appeal 22-001. Appellant Douglas Kurzweil, part of the northeast one quarter of the northeast one corner, lot 2 Alpha CSM, book 6, page 382, document number 1318, section 16, town 40 north, range 07 west, parcel 012-740-16-1102, 1.02 total acres, zoned residential recreational 1, RR1. This appeal is against the zoning administrator's decision regarding the old Aero resort use falling within the definition as a resort. Does anybody have objection to the determination of jurisdiction?
Seeing none, we can proceed.
Will the official whose decision is subject of the appeal statements and presentation of evidence step forward?
Thank you, Board of Appeals members. Jake Kozlowski, Sawyer County Zoning Administrator. I want to kind of give a narrative of the history and the background. On July 20th, 2020, a land use permit number 20-252, was issued by Sawyer County Zoning Department for the reconstruction of an existing dwelling located at the parcel 012-740-16-1102, site address of 11035 Aero Road. This property contained 2 existing habitable dwellings that were lawfully placed when constructed. The ordinance had since changed on June 20th, 1985, that would only allow for 1 habitable dwelling per lot, or to meet the dimensional requirements as specified per that zone district. Since there were 2 habitable dwellings in existence prior to June 20th, 1985, Sawyer County zoning would allow for the replacement of an existing non-conforming dwelling unit and also allow expansion of that dwelling unit up to 50% of the existing floor area. There are multiple properties in Sawyer County that have 2 existing habitable dwellings on 1 lot. Between July 20th, 2020 and September 17th of 2020, Mr. Kurzweil had asked me in person with an office visit about short-term rental procedures for 2 existing dwelling units on the same property. Whether this is something that would be classified as a resort. On September 18th, 2020, I took this new business discussion item to the Sawyer County Zoning Committee, the Committee of Jurisdiction, as to ascertain how this type of scenario should be viewed. During this discussion, the committee stated in summary that they would allow rental of 2 existing dwelling units on the same parcel, and that the zoning committee felt it would not be a resort type use if the rentals do not exceed 2 dwelling units on the same parcel. Also, that a resort would have other amenities offered, such as a central lodge, laundry facility, and or bar restaurant. This discussion was brought to zoning committee to establish office policy until a finalized ordinance amendment could take place. On July 20th, 2021, Mr. Kurzweil sent me a letter of a formal written determination regarding the operations at the property address of 11035 Aero Road. Mr. Kurzweil's claim is that the property is being operated as a resort and has since been a discontinued non-conforming use and should no longer be operated as a resort. I agree that the pre-existing resort use has been discontinued, but it is my determination, as outlined in my letter back to Mr. Kurzweil dated September 24th, 2021, that it is not being operated as a resort. This determination was bolstered in discussion by the zoning committee. It was also further discussed with legal counsel at the time, Rebecca Roker, and that Wisconsin law required to look at the actual use and not what it is called or being advertised as, such as in this case, Old Aero Resort LLC, and that would just be a form of ownership. In respect to the Sawyer County zoning ordinance definition of resort, a resort is for profit business holding a seller's permit or license by the Wisconsin Department of Health and Family Services. That is now held through the Sawyer County Health Department as an agent of the state. This provides rental to public of dwelling units contained in 1 or more permanent buildings used primarily for recreational use. That is the definition of the ordinance. If we are to use this definition, then all short-term rentals, even for 1 dwelling unit within the county, would be established as a resort. This clearly is not the intent of the ordinance, that by allowing short-term rentals through the health department's licensing procedure, even for the 1 dwelling unit, we would have over 500 non-compliant illegal resorts within the county. If the BoA was specifically to look at that resort definition, again, we have created now over 500 non-conforming uses. While this circumstance of renting 2 existing non-conforming dwelling units on the same lot may be slightly different and unique for 11035 Aero Road, it should also be mentioned that there are 6 other properties in the county which are currently taking place with 2 rentals on the same lot, and 2 others that are pending whether their determination is made here tonight. While we may be discussing 11035, it does have implications elsewhere. Thank you for your time. I can certainly answer any questions you may have, and I would like to reserve the right for additional time for rebuttal if permitted.
Okay, thank you. Any questions at this point? Okay. Anyone else to speak on behalf of the application?
My name is Attorney Steve Sorensen. I'm appearing here on behalf of the zoning department, on behalf of the county, who've asked me to participate. You've heard the statement that was made earlier by Jay that he did contact our office. I'm from Von Briesen and Roper. As a firm, we represent many counties throughout the state. I've been a municipal lawyer for over 40 years, represented the county in a few cases recently. My expertise is in zoning and waterfront property. The key consideration here is, and I think it's really relevant, is if you look at your 3 factors as I see them. Number 1 is the role of a zoning administrator. If you look at your definitions in your own bylaws, in your own code sections, you'll find that a zoning administrator's responsibility is to administer the rules and regulations. Part of that job of administration is to interpret. Many counties, in fact, have the word interpret right in the ordinance itself, saying that your duty and responsibilities are to apply the law to the facts. And in this case, that's exactly what your zoning administrator did. But let's talk about a little further what he did. Not only did he apply the law to the facts, but he went one step further. He went to the committee of jurisdiction. And I think that's very, very relevant. He went to the county board committee that's responsible for zoning, and that committee gave him a specific instruction. And that specific instruction is what he talked to you about today, that he utilized in determining this was not a resort. And I think that's very significant. So it's not only his decision, but it's the county board's committee of jurisdiction's decision that they implemented also. Then he went one step further and he sought legal counsel. And at that time, the county was without a corporation counsel. You now have Mr. Duffy, but at that point, Rebecca Roker was serving in that responsibility. She gave him the exact definition. She gave her the basis. Now, again, let me add a little bit to the why is this not a resort? Because I really think that's the crux of the decision. Having spent a lot of time in a lot of different counties, having become a specialist in waterfront, a resort is, and the definition that's most often utilized when discussing what a resort is it's looking at a facility that provides services beyond just living facilities. I mean, that's, you have a residential facility, but a resort facility has amenities. And if you look at the definition that's used by the industry itself, the resort industry, they talk about it's a facility that provides services in addition to residential. It provides a bar, it provides food, it provides other services, it provides boats, it provides all these other activities that would be characteristic of a resort. I think it was the Supreme Court that put it this way, and I think it's really important if you think about this for just a second, the concept that you can call something whatever you want. And for example, I can have a goose sitting right here. I can call it a duck. I can say it's a duck. I can refer to it as a duck. But guess what? It's got a long neck. It's got the right colors. It's got the right feet. It's not a duck. It is a goose. And that's exactly what you have here. You have two residential properties that are legally on this property that are being used as rentals, not as resorts, but as rentals. Now, simply because they use the name resort simply doesn't give it any credence because you can call it whatever you want. Finally, this is where I want to leave this because I think this is probably the most important aspect of this, and I'll be more than happy to discuss things further if you want to go into case law that Rebecca cited. I'll be more than happy to do that. But the bottom line here is who's got the burden? It's not the administrator's burden. It's the applicant's burden to show under your ordinance that an injustice was done or that an error was committed in which both the facts and the law would prove that injustice was done and an error was done by the administrator. I don't think that exists at all. I read through all the materials. I see no injustice. I see no error that was done. In fact, I see somebody that applied the law correctly, took the steps that an administrator should take, probably went above and beyond, and I think you should support him. Thank you.
One moment. Go back to your explanation of being able to call something anything you want.
Yep.
Isn't that misleading?
Absolutely. But that's not illegal. That's not improper. I call my cabin BS Haven, okay? Far from a haven. At times it's a hellhole.
About the BS.
The BS is because my wife's last name was Bradley, my last name was Sorensen.
I was putting a different spin on okay.
I would find many people, Chairman, that would call it BS Haven because there's lots of BS. I understand that. That's what cabins are for. But what I'm trying to say to you is we call lots of things something different there. We call restaurants inns. You don't sleep in the restaurant. Why? Because inns used to be restaurants and places where people lived and stayed. I mean, that was the old definition. And what I'm trying to say to you is that doesn't define the element. What defines the element that's important to you is what's actually happening. What are the, as your code says, what are the facts? What are the facts as to usage? What are the facts as to how it is advertised? What are the facts as to how it's used? Because use is the key. Use is your key. How is it being used? Is it being used as a resort, or is it being used as a single family residential rental? And I think that's the answer.
Thank you.
Any other questions? I didn't mean to run away. Thank you.
Thanks. Before I ask for additional testimony, Jay, I have a question of you I should have asked when you were at the microphone. In the package that we were provided with, there was a couple back and forth letters exchanged between you and Mr. Kurzweil, and one of them, in the original letter, you referred to RR2, and then you followed it up with that was a misstep, and it was really zoned RR1.
Correct.
I was looking through the manual that we get, provides all the ordinances, and I got to permitted uses in RR1, and maybe I'm looking in the wrong spot, not drilling deep enough, but I didn't see resort in that permitted use list of 7. And then I looked in RR2 and I didn't see resort as a permitted use in RR2 either. So maybe I'm just not.
No,
finding it.
and nor is it a permitted use in either of those zone districts. It would be a use authorized by conditional use permit process. So you're looking at subsection A, and really you'd be wanting to look at subsection B. Now, unfortunately for this situation, for the subject property that we're discussing, in order to apply for that type of conditional use permit to operate what's known as a multi-dwelling development, which fits in the terms of resort, condominium, I think there's a few others in there, you would still need to have the minimum lot district requirements in order to apply for that conditional use permit. So in essence, if you had a 200-foot wide lot and you had 200 feet in depth, you could legally split that into 2 separate lots. Instead of actually splitting it into 2 separate lots, we carved out that portion to not dictate that one house has to go here and meet setbacks, one house has to go here and meet setbacks, that you can do a conditional use permit and you can put the houses where you want on that one parcel. But again, it requires the grantal of a conditional use permit. For this circumstance, they don't have the land nor frontage nor lot configurations in order to further seek that conditional use permit approval process.
Well, just very quickly glancing at.
It should be at the last subsection of B under multi-dwelling development.
In RR1 or RR2?
Both.
Multi-dwelling development.
It was an error in my letter that I stated that the property was zoned RR2. I then later made that correction to reference that it is zoned residential recreational 1. But in speaking in the terms of this case, whether it was RR1 or RR2 wouldn't matter for this individual circumstance.
Okay, I'm looking at it as subsection, I don't know if that's the right word or not, 15 under multi-dwelling development. It says a new condominium, hotel or resort or other development.
Correct. So if you had
So are you determining this to be a new resort?
I'm not determining it to be a resort at all.
Okay. Okay, that's the only question I had. Thank you. Okay, is there anyone else to speak on behalf of, I keep calling it a variance request, but it isn't. It's a, speak on behalf of the appeal. Okay. Hearing none, is there anyone to speak in opposition? Hello.
Hi there, Linda Coleman. I presume this would be the time for the appellant to come forward. And so I'm going to let my client speak first and then follow up with some more information.
Yeah, you are correct.
Thank you.
Thank you.
Douglas Kurzweil,
11055W Aero Road, Hayward, Wisconsin, 54843. I don't want to take much of your time, just a little bit of facts here. I think my position is quite well spelled out in the paperwork submitted with my appeal. I would just like to call your attention to the timeline of the redevelopment of Aero Resort, and that basically is enclosure 3 in the packet. It starts with 3/31/2017 when Old Aero Resort LLC was incorporated. And then it's just a brief timeline of what has happened on that property since then. And as you get to the end of it, I do talk a little bit about resorts and amenities and many resorts in the area that don't have them. Another item of fact is enclosure number 4, which is a copy of the filing from Wisconsin Department of Financial Institutions, indicating that Old Aero Resort LLC is indeed organized and incorporated in the state of Wisconsin. My next item is there's a couple of photos. It has to do with the promotion and advertising of the business as a resort. And there's some photos, the white arrow signs down at 6 Mile. The picture out in front of my house, that's my house in the background. I think it's on the other side of the white arrows. And then also there should be a copy of a page from last year's Hayward Lakes Visitors and Convention Bureau Vacation Guide with the ad for Old Aero Resort. And I also happened to pick up the 2022 edition today, and it also has one, and I submit these.
Yeah, you won't get them back.
That's fine.
Okay. Thank you.
Promotion and advertising signage, print media, and online in quite a number of platforms as a resort. And then the on-the-ground operation. Since late June of last year, that is when the second unit came online and began being occupied for weekly rental. The on-the-ground operation actually confirms, and this is something that I and the owners would agree on, it is being operated, as they say in their website, as a small resort. And also, I have here a copy of an email from Matt McKay, who I believe is the County Department of Health individual who deals with licensing of these things. And he indicates that in his discussions with the Department of Revenue, if the operator uses a VRBO and/or Airbnb, they would not be required to have a seller's permit. Should the operator use any other platform to advertise, own website, Craigslist, they would be required to obtain a seller's permit. For any new facility looking for a license, we inform them that they need to contact their local township to see if they have any other requirements for rental properties, the room tax. And I'd like to submit this for the record.
Would you state again who that email is from?
Matt McKay,
And in his capacity as?
he works for Sawyer County Health, and he is the gentleman who issues the state DHS licenses for Sawyer County.
Okay, thank you.
And I guess that's pertinent facts that I would like to be fully considered. And there's a number of issues with the law here, both state statutes and the county zoning ordinance. And I will defer to council to speak to those.
Thank you.
Any questions?
Appears not at this time.
Thank you.
Thank you.
Good evening. As I said, my name is Linda Coleman. I work with Spears Carlson and Coleman out of Washburn. Like Attorney Sorensen, I too have worked in the area of zoning and regulation for the past decade in my case, including as Corporation Counsel for Bayfield County Zoning Department. I'm here today to represent the appellant, Mr. Kurzweil. And I took some notes while Attorney Sorensen was speaking. And one of the things I heard Attorney Sorensen say is he wanted to tell you about the most often utilized definition of resort. But here is the black letter of the law. We're here today to talk about your definition of resort in Sawyer County. We're not here to talk about what other counties do or how they've defined resort. We're here to talk about Sawyer County. And I really wanted to call your attention to that language, because I think what we have here is a very straightforward application of a very straightforward definition. So I've given you the definition, two definitions, one of resort, which is the most important point here today, and the other of dwelling unit, because that term is referenced within the resort definition. So as you'll see, a resort is a for-profit business holding a seller's permit and licensed by the Wisconsin Department of Health and Family Services, which provides rental to the public of dwelling units contained in one or more permanent buildings used primarily for recreational use. Now, I heard the zoning administrator tell you, well, if you interpret this use that's before us today as a resort, that means every short-term rental is a resort. And I submit to you, he's plainly wrong under your own definition, because the resort requires rental to the public of dwelling units, not one or more dwelling unit. A rental to the public of dwelling units, plural. Your definition requires that there is more than one unit that is rented. And I've included the definition of dwelling unit below. Importantly for this case is simply that both of these structures are dwelling units. There is a rental of dwelling units, not unit in this case, and therefore this is a resort. If you look at a more common use of a house as a short-term rental, that would be a rental of a dwelling unit. It's not rental to the public of dwelling units. It plainly doesn't meet the definition. What does meet the definition is rental of more than one dwelling unit. And that makes a lot of sense. This is a resort. This is not one person's home that can be rented out on a short-term basis. And I want to address the elephant in the room of short-term rentals. Short-term rentals have become like the third rail for municipalities because the state legislature has given a lot of freedom to short-term rentals and taken away a lot of local control over short-term rentals, which some people might consider unfortunate. Short-term rentals often look like a person from out of the area purchasing a local property or properties, renting them out from afar to a new party every week. And when I say party, I mean a party. A group of people who's there for a few days to have a good time, who doesn't particularly have ties to the community or particularly care about the neighbors that they may never see again. It looks quite different from somebody who you live next to for a long period of time and starts to care about their neighbors. But be that as it may, the legislature of the state of Wisconsin has taken away a lot of the ability to impose any restrictions or regulations on these short-term rentals. However, they have only sanctioned and they've only taken away that control for a rental on a lot, not multiple rentals on a lot. And what we have here is multiple rentals on a lot, which you heard. This is a standard size lot. You can't divide it up and meet requirements because it's fairly small. And now we're going to have 2 units on this property being rented out to various parties at various times, who again, likely have little tie to the community and to the neighborhood. And the legislature does not prevent you from controlling that. Your ordinance says that not only should you, but you must. This meets your definition of rental, and I haven't heard any argument today that it doesn't. There's been a little discussion about grandfathering. I thought I'd touch on that. There's a difference between a structure being grandfathered and a use being grandfathered. We take no issue with the fact that there are two structures on that property and that they were renovated. That they were allowed to do that. But I think even your own zoning administrator acknowledges there's no grandfathering of a resort. First of all, the resort didn't exist at the time that the ordinance was passed. And I believe the testimony from the zoning administrator is that that was in 1985. In 1985, there was no resort there. So it was not grandfathered. But even if there had been, everyone agrees that it fell out of use for many, many years. And so for both of those reasons, it would never have been a grandfathered use of a resort. So it's not a grandfathered use. And that brings us back to the central question, in the way that the zoning administration is getting around this is saying, well, okay, it's not a grandfathered resort. Tell you what, it's just not a resort. Why? Well, because we think resorts have to have certain amenities. I don't know where that comes from. It's not in this definition anywhere. It's not applied to many other resorts. There are plenty of resorts in Sawyer County that are treated as resorts that don't have a clubhouse or a restaurant. How many amenities do these resorts need? Are there specific ones that the resorts need? Is there a total number of amenities? That's not clear. So that idea that this is not a resort because it doesn't provide amenities fails. If Sawyer County wanted to decide that we will only consider resorts to be, we will only consider a use to be a resort if it has amenities, then Sawyer County has every right to pass an ordinance, to adopt an ordinance through a public process where you invite public comment and you have folks weigh in on, hey, do you think that we should allow 2 or more structures on one single lot to be rented out as short-term rentals? Or do you think that's a resort and we maybe shouldn't do that? The public should get to weigh in on that, but they haven't. Instead, the zoning administration has said, well, we think that there should be more amenities, and this doesn't have amenities that we think should maybe accompany a resort, even though they always don't. That's not the way this works. Sawyer County is within its rights to amend its ordinance if it wants to, but it has not done that. We sit here today with this definition of resort. I would query, what part of this definition of resort does this use not meet? It's a pretty clear definition. I don't think it's particularly ambiguous, and I don't see any portion of it that is not met by the proposal for 2 units on a single lot, 2 dwelling units, multiple units, to be held out to the public for rent. And unless we can find a way that this does not meet this definition, I would say that your duty is to find that this is a resort. I would also point out to you that that is absolutely within your power to do. Attorney Sorensen talked about the burden here. Well, the reality is you, as the ZBA, have the absolute authority to substitute your judgment for the judgment of the zoning committee, the zoning administrator, or both. That's your right. You can look at what they decided and say, no, I just disagree. And that's enough. You have the right, and I think you have the duty, because I don't think that there's any evidence before you from which you can say that this proposed use does not meet this definition. I also disagree with the analysis that this would make every short-term rental a resort. It does not, because your definition requires units, not unit. Your zoning administrator indicated, well, there's apparently 6 properties where there are 2 units on a single lot operating, and maybe there's more coming, apparently, that we need to decide what to do with. I agree. Sawyer County needs to decide what to do with this. The way that that should happen is that we should look at our current ordinance and apply it. And if we want to make changes, we go through the public process to present that to the public and find out, what does the public think about this idea? Until that happens, I submit that you have a duty to abide by the terms of the ordinance as it is written today. That's all. I'm happy to answer any questions if you have them.
Are there any questions? Okay, thank you.
Thank you.
Anyone else to speak?
Linda Zilmer, Edgewater property owner, 902 Holly Hill Lane, Birchwood, Wisconsin. And I'm speaking to you today as having 17 years of experience since 2005, regularly attending monthly zoning committee hearings. I've attended a few of these hearings and have participated as a applicant in both forums. Many of those early years, your corporation counsel tonight, TJ Duffy, was the corporation counsel for the county and was present at zoning committee hearings. For years and years and years, I've heard the issue of tourist rooming houses kicked down the road. First, there were maybe only dozens, and did we need to regulate them? And then it would come up periodically every year or every couple of years, and there got to be too many where they felt that it would be really hard to step in. And then also there was a concern with the discrepancy between what is the state authority versus the county authority to license or permit. And so Sawyer County has not chosen to address tourist rooming houses. But Mr. Chairman, in the beginning of your speech, you did point out that resorts don't appear as a permitted use in either RR1 or RR2. And unless the version of the ordinance I'm looking at online, I don't believe tourist rooming houses are permitted use in either district either. And I just wanted to supplement that because unless I missed it, I didn't hear the other attorneys mention that either. Thank you.
I was corrected in my original statement, and it does appear in the ordinance. I just didn't find it.
Mr. Chairman, could you clarify, because I'm saying that neither resort or tourist rooming house appear as a permitted use. What are you?
I wasn't looking for rooming houses.
Oh, no, but you said resort.
Yeah, but I found it. It does appear.
As a permitted use. It's a conditional use. Yeah, and I think the issue here is permitted versus conditional. And part of the history I just gave you, as a public comment, I have often come before the zoning committee arguing that the Sawyer County definition of resort requires conditional use permits for a situation like this. And I would even argue that for a single VRBO, but obviously the county did not agree with my opinion. Thank you.
Thank you for pointing that out. Is there anyone else to speak? Would you like to take down the microphone and remain seated? Would that be more comfortable for you?
It's okay.
Okay.
Laura Rusk, Chairman for the Town of Hunter, and I am here representing the Town of Hunter Board, and any statements I make, I am once again representing the same thoughts that the Town Board has. It is our position that the zoning administrator's determination regarding Old Aero Resort is incorrect for all the same reasons that were just outlined by Mr. Kurtzwell and Ms. Coleman. The business he is operating is not a short-term rental home, but rather, as he himself advertises, a resort, offering multiple dwellings for rent. This is in clear violation of the permitted uses under RR1 zone district. His intent to run these units as rentals has been clear from the beginning of his renovations. And our argument is not that Old Aero Resort cannot operate. It is that he is doing so now without proper zoning or a conditional use required. The ordinances are written specifically to cover these types of scenarios and should be interpreted to reflect the intent. There is no definition of a resort as being a place with a bar, restaurant, and a game room. Old Aero Resort may very well be granted a rezone and a conditional use permit after he is required to apply, and opinion letters are sent out, and conditions reflecting the input of the various entities involved, such as the Planning Commission, the town, and the Zoning Committee, provide their input as to the conditions that should be applied. This is a residential RR1 neighborhood, and the zoning ordinances were written to reflect the values in different zones. I guess without going over the same things that have already been run through, you saw in your packets the information and the timeline. And what we're saying is, it isn't that this is not a possibility for the TOSEX to run Old Aero Resort. What we're saying is they need to apply and do it properly. They need to be zoned properly, and they need to obtain the required conditional use permit to do so. That is the proper procedure, and I'm sure in the same procedures any one of you would want to apply to yourselves in your situation to implement a change of use in your zone district. That's all.
Okay, thank you. Anyone else to speak in opposition? You should probably state that again when you're close to the
My name is Benjamin Kurtzwell, resident of Sawyer County. Just something quick. The contention that resorts include amenities such as a lodge, restaurants, game room, etc., is based on a discussion, not on any language, text, or definition in the Sawyer County zoning ordinance. In reality, many resorts have none of those. On the Chippewa Flowage, you have Timber Cove, Muskie Joe's, Reader's Recess, Oak Shores, and Mayo's Golden View come to mind. Mystic Moose Resort on Moose Lake and Crest Hill Resort on Lake Placid are two more, and there are many others. Old Aero Resort LLC does have something you rarely see anywhere but at a resort, a fish cleaning house. Thank you.
Okay, thank you. Anyone else care to speak? Mr. Kozlowski, would you care to provide any additional information or background?
Clarification. I'll go back to the definition of resort.
Probably re-identify yourself, sir.
Oh yeah. Stephen R. Sorensen, attorney from Von Briesen Roper, representing the county, representing the zoning administrator office. Several decades. I wish it weren't that many, but it is. The definition of resort, okay? I mean, that's really what we're talking about. It's our opinion this is not a resort. I mean, all the discussion about whether it is a resort or is not a resort is really what the issue is and the definition. We're not here to say the state of Wisconsin is taking away your rights or anything like that. The reason there's an appeal, and this is really what I think has been lost, is whether or not the zoning administrator, whose job it is to administer the zoning code, did his job. Did he do something that was improper? Did he violate the rules? Did he do something, in opposition to the code? Did he do something that he wasn't supposed to do? And as I said before, it's not about how this property is advertised. Everybody wants to talk about how it's advertised. Well, if you look at their own exhibit that they gave you, there's not one mention of resort in the ad. A quiet family-based, peaceful, secluded area, indoor fishing, cleaning station. It goes on and on and on in the definition. It doesn't talk about two dwellings. It doesn't talk about multiple housing. If you look at the one right next to it, which is Johnson's Resort, which is the one that talks about all those kind of things, there's a distinct definitional difference between that. Again, I want to go back to your definition because everybody wants to talk about your definition. And you have to understand that the role of an administrator is to interpret the law and interpret the ordinance. That's what you hire him to do, or her in some cases, to do. And that's what he's doing. And that's why we're here. We're just simply saying he did his job. But look at the definition. A resort is a for-profit business holding a seller's permit. Every single facility that rents for short-term must have a seller's permit. That's the law in the state of Wisconsin because they have to have a seller's permit because they have to pay a room tax. And the only way you can pay your room tax is with a seller's permit. So let's get that out of the way, first of all. Every short-term rental, I don't care if it's a single family, I don't care if it's a multifamily, you have to have a seller's permit. So if anybody that has an RV, a vacation rental by owner, you have to have a seller's permit so you can pay your seller's, your room tax. It's required by the statute. So there is a room tax. Yes, he's got a permit. Licensed by the Wisconsin Department of Health and Human Services, which is required again if you're going to have short-term rentals. So those two definitions are, as Jay pointed out, the reason you've got 500 other properties that'll fall under this definition, if that's where you stop. If you simply say a residential or multi-residential dwellings on a single lot, and it doesn't talk about multi-residential on a single lot, by the way, it just says if you hold out dwelling units containing one or more permanent buildings used primarily for recreational use. Okay, so let's go through those definitions. First of all, is it a dwelling unit? And the answer is yes, but so is your home. So is every single property on the lake that's used as a dwelling. Those are dwelling units. So you're going to include every dwelling unit. But let's go to what distinguishes it. It says used primarily for recreational use. So what's recreational use? Well, if you look up the definition, it means a business providing facilities for golf, water sports, skiing, or similar sports and recreational activities, including adult entertainment even. That's your statutory definition. So what's the business use here? Now remember, in this definition, you start, a resort is a for-profit business holding out the seller's permit. So are we operating a business out of this location? And second of all, are we operating a recreational business or are we operating a rental business? Just like everyone else that rents their property out for a short period of time. That doesn't make it a resort. You know, it's frustrating, I guess, because yeah, you could do a lot of things. You could rewrite the ordinance. You could have the county board do this. You could have the county board do that. But what did he do wrong? He went to his county committee of jurisdiction. What more would you ask him to do? They told him that this didn't qualify as a resort. They said if there's not more than 2 units, we're not going to classify it as a resort. That's the committee that makes the rules. So he took their ruling, but he also went and talked to attorneys who are experienced in this area. And we gave him the same response. What is the state definition? A resort is a self-contained destination that can provide for your travel needs in one location. You can find food, drinks, entertainment, shopping, and other activities, all without needing to leave the property. That's your state definition. It's from your own state association. Now, is it the definition that's in the Sawyer County ordinance? No, absolutely not. But what is he supposed to do when he's trying to define resort, when he's looking at 2 dwelling units on a single property that are being used the same as everybody else that's renting out their dwelling units for short-term rentals on the water? And I think really that's what this is all about. If you get down to the fact that what an appeal is on a decision that was made by your administrator using your committee of jurisdiction, utilizing legal assistance that was provided by your county, I think he did what was proper under the circumstances and he followed the rules, and I think he should be upheld. Now, if somebody wants to change the ordinance, somebody wants to correct the ordinance, there's a procedure for doing that. But as it's written and the procedures you have, I think your administrator did the job you asked him to do, and I think you should uphold it. Thank you.
Couple of things. You had us look at the ad.
I read the ad that what they presented.
Yeah, and you said the word resort does not appear.
I didn't say the word resort doesn't appear.
Yeah, you did. But,
No, I didn't.
That's what I heard. But
I said there's no recreational business that says it.
the first 3 letters in the ad are Old Aero.
That's the name of the business. It doesn't use the resort.
I think you said the term resort didn't appear.
The
But
concept.
anyway, that's.
Yeah, okay,
that
so
doesn't- that doesn't-
I'll concede it says the resort. I conceded that before. I told you that my example, you call it a goose and it's really a duck, it's still a duck.
Yeah, and then the other thing is, I agree that the zoning administrator did his job. He delivered the message that the zoning committee, if I'm saying that correctly.
Correct.
Told him to deliver. So
Right.
I don't think this is the administrator exerting his will. I think it's him delivering the message that, that the zoning committee told him to deliver.
Look at the ordinance. The ordinance says that you have to find that he violated the rule, that he did something wrong. And I'm just asking you, tell me what he did wrong.
Okay, well, thank you. Did you have anything else, sir?
No, I
Oh,
just,
okay, thank you.
Thank you.
Anyone else to speak?
No, that's not either.
Yeah, that doesn't come in. This time, if no one's here to speak in rebuttal of the official whose decision is being appealed, we can move on to questions by board members.
I would like to speak.
Yes, we can allow that, can't we, Pat?
That's correct. Rebuttal of the official.
Jay Kozlowski, Sawyer County Zoning Administrator. In the end, yes, I mean, certainly, look at the definition and whether or not I use the correct judgment in making that determination or not. But in the other aspect, going to that committee of jurisdiction and bringing this issue before them, they instilled in me office policy to change the ordinance. I haven't gotten to the point of changing the ordinance yet, and that process takes a long time. But the ordinance is to be changed at the discretion of the Sawyer County Zoning Committee. I presented the issue to them. They saw the issue that I had as well. We made a determination and basically established a short-term office policy to give me the time frame in order to correct the ordinance so that it reads and it is interpreted as the black and white. And that is, I guess, my last statement I would like to make. Thank you.
If that is all the rebuttal by the official is being appealed, then we can move on to questions by the board members.
Can we ask for Kurzweil or Kurzweil's representative to make an additional statement?
There,
Oh,
correct.
right,
And they can respond to questions.
Yeah.
And
Do I have the opportunity to speak?
And who are you, sir?
I am David Tochek, the property owner of 11035 West Aero Road.
Yes, you will.
I mean, probably just go up there. We don't want him to speak here, I'll put this, that speaking.
Sir, yes, you'll be able to make a statement.
Okay, and may I proceed then?
Yes.
Okay, thank you, sir. I would just like to state generally that I need to give you guys a little background because everyone keeps on saying resort, resort, resort. Well, of course, you're going to see it everywhere that it's advertised because that is the name that we chose to give the place. So you're going to see resort on the website. You're going to see it here. You're going to see it in books. It's the name. My thing is, when I renovated these cabins, I grew up there and it was Aero Resort, formerly owned by Nick and Sophie D'Orazio. Those are the memories that I had as a young man. When I restored these, I asked their son, Dave D'Orazio, for permission to name it Old Aero Resort, in memory of the resort, not considering that this was a resort, would be operated as a resort. To me, I think that I always envisioned tree lands being a resort, Dunroven, places with amenities that are a large operation. This is a small business of 2 dwellings on 1 property, individually being rented, and I do not consider myself a resort. If I knew that it was going to cause this kind of confusion, we would have just simply named it Old Aero Cabins. And I apologize for that and any misconception, but we side with Jay and agree. Also, I'd like to point out, because we did name it a resort, we did go one step further, and it is advertised on our website. It clearly says we are not a big resort with a bar and restaurant. So that's how this business was established under your guys' ordinance, assuming that a resort has a bar and a restaurant, just like everyone else has stated. And if you look at our website, it is clearly advertised there. And so if this is a matter of, us advertising incorrectly or using the name resort, we can adjust this. But really, that's all I would like to say at this time.
Okay, thank you.
Yes, sir. Thank you.
Since we kind of batted out of order here, that testimony should have been heard earlier. I think we now need to allow a rebuttal, which would give anybody else an opportunity to speak. And if you do choose to speak for the first time or speak again, please state your name.
Thank you, Linda Coleman. First, I want to say I'm flummoxed and concerned by the comment that you must find fault in what the zoning administrator did in order to reach a different conclusion. You'll consult with your own attorney, but I believe he's going to tell you that's not accurate. You have the absolute right to substitute your judgment for the zoning committee, the zoning administrator, or both. And that's your role. You're the judge. And there was a lot of talk about what your county decided and your zoning administrator and your zoning committee. You're not on their team. You're here as the judge. You're here to look at this fresh and to look at the definition and determine whether you agree that this is or is not a resort. That's your role here. And so I'm not accusing Mr. Kozlowski of any terrible motives here, and you certainly don't have to either. You are perfectly free to disagree with him, and you should if that is your judgment. I'm confused by this idea that there's some short-term policy that changes the definition of resort in the interim before we actually change it. That's not how the law works. We deal with the laws as they're written, or in this case, the ordinance, and we apply the ordinance as it's written unless and until it's changed. I'm also concerned about the comment that this is going to be changed. We can't know that. There has to be a public process to amend your ordinance. It's not up to Mr. Kozlowski. And while it is up to the zoning committee eventually, only after they get public input and people have a chance to know about this and make a decision and voice their opinion as to whether they want this kind of change. I want to bring it back to the definition of resort. I hang a lot of meaning on the words of the definition, as you should as well. Dwelling units makes clear that it must be more than one unit. I'm not asking you to declare all short-term rentals resorts. They're not. They would not meet this definition. A one home that's being rented on a short term is not dwelling units. Doesn't apply. Anything more than one, it applies. And whether it should or shouldn't apply, whether we should require that it also has to have amenities, that's a question that can be addressed. But as we sit here today, I don't think this definition is confusing. I think it's pretty straightforward. And I'm just asking that you apply this straightforward definition to the uncontested facts of this case, that this is a resort. Thank you.
Want another kick at the cat?
Question, just because it's important. You are not hearing this de novo. This is not a de novo process. That's what was suggested, that you can start from scratch. That's not what you're doing. You're deciding whether or not he complied with his job responsibilities, just as your ordinance says. And I'm sure that your attorney will tell you that. Thank you.
I don't believe we have taken additional testimony, have we? No, we've heard from multiple sources, but it isn't anything that, whatever. The questions by a member of the board. Does anyone have any questions or need any clarification of definitions?
You know, it's cumbersome to me, Al. So if we're looking at this and it says, you know, it says more than one unit. So it doesn't say all in one spot. So somebody starts Round Lake LLC and they own one cabin on Coudray, one on Grindstone, and one on the Chippewa Flowage. Does that then mean that they are a resort?
Yeah, it's confusing to me also. Jay, in your discussion with the zoning committee, was the possibility of requiring a conditional use permit discussed?
Jay Kozlowski, zoning administrator. Yes, it was. And as I previously discussed, you would only entertain a conditional use permit in that circumstance if you met the zone district requirements to have multiple dwelling units. Specified in the back of the ordinance, section 18 is dimensional requirements per zone districts that would contain a dwelling unit. And that's where you would need a minimum 100 feet of width that would be measured at the lake shore to a depth of 200 feet and 20,000 square feet. That's per one dwelling unit. In order to have the second dwelling unit, you would need double that amount. And this property does not have that land area in order to further apply for that type of conditional use permit. Other properties do, and that would be their appropriate route. If this board was to determine that this use met the definition of a resort, they wouldn't be able to apply for the CUP, but other properties would. Does that make sense?
May have confused me even more.
Yeah. Now, in this circumstance, again, though, you have two existing dwelling units. It's a non-conforming use in the form of there's two existing dwelling units that were in existence before the zoning ordinance code changed that would only allow one dwelling unit per lot. And that was, again, reiterated by the appellants, that they're not arguing that there was two existing dwelling units here. You can keep the two existing dwelling units. It's the further use of the issue and whether or not rental of the two constitutes a resort.
Okay, that's the definition I was looking for. Thank you. Okay, any further questions? No. Of either the appellant or the zoning administrator?
I presume that those things have a seller's permit?
They do.
They do? All right, okay. Yep. Which they would need even for
Correct.
Jay, if they were just renting one unit and keeping the other unit as their personal recreational cabin, would we be here?
I do not believe so. Unless, again, someone was to file an appeal of that determination.
One other question, does that the room taxes are enacted by the individual townships, are they not?
Yes.
Are they not individual, the room taxes by the individual townships? So does Town of Hunter have one? Okay. But if he was in a different township that didn't have room tax, then would he not have a seller's permit?
I believe that's a state statute. I guess aside from the.
State your name, please.
This is Laura Rusk, Town of Hunter. Aside from trying to make this sound like we are trying to make Jay the bad guy, that he, that's not what this is about. My main thrust here, which I'll reiterate again, we have zone districts, and the ordinances provide for permitted uses and uses that can be obtained with a conditional use permit if you're zoned properly. By all admissions, TOSECs are running a business, a rental business of more than one unit. This is not the short-term rental of their home or a vacation home. It is a business. And that is not a permitted use in the RR1 zone district. They need to apply for a rezone to RR2, and at that point, apply for a conditional use permit in order to meet the intent of our ordinances. It isn't just a single home being rented.
I mean, if you allow questions, I think she testified. I think you would allow them to respond to it.
Okay, is there any response to the most recent statement?
Jay Kozlowski, zoning administrator. In my interpretation of the zoning ordinance, if you were to, rezone the property to residential recreational 2, A, it would probably be considered spot zoning. And B, I still, as the zoning administrator, would not interpret the ordinance that you could apply for a conditional use permit in that circumstance. There are no options for using the conditional use permit clause, as I see in the ordinance, to operate this as a, by definition, resort. Again, when I look at the resort definition, dwelling units contained in one or more, whether or not it says, the plural S, and maybe the plural S should have been in parentheses, it does further state one or more. And that's where I look at it, that if we're using that black and white definition resort, it would also be my interpretation that every single VRBO, Airbnb, short-term rental would be classified under resort.
Thank you.
Now, one thing I would, when she talked about business, and there was a appellate court case in the city of Hayward where normally LP House on the Lake Hayward, there was a deed restriction on that property that said no businesses may be operated on that property. And so the neighbors, when he started operating as a vacation rental, they filed an action to stop that, saying it was a business. And the appellate court said the business is not being operated out of the house. What's in the house is recreational. It's family living, whether it's him or a rental property. The business may take place out of his home or over the phone, but the business wasn't being operated out of the home, the rental home. That was residential use, not business use. And so that case, which our circuit court sided with that it was a business, the appellate court overturned them and said the use was not a business. The use was residential and not business. And that was right here in Sawyer County, in the city of Hayward.
Okay. Thank you. Any further questions of the board? Any further discussion by the board?
I would just like to say that using the word resort to me is a tribute to the former owners. Just because you call something a resort does not mean that it's a resort. You're using the name for identity. A lot of places do that. They keep the old name even though it's not any relation to the people that owned it. because the people know where that place is.
Okay, thank you. Any further comments by the members of the board? Does anyone care to make a motion either for or against the appeal?
In some ways, our hands are somewhat tied with limitations of the definition, the change in the industry. I agree with the discussion that I don't think a resort has to have a bar, doesn't have to have a tennis court. I don't think it matters if it's 1 or 20 units. So this is a big challenge, and I don't admire what Jay has had to go through. These are tough decisions.
Since it wasn't in, or doesn't appear to be in our ordinance that resorts need to have those things, it was probably an error to include that statement rather than follow the strict definition that as it appears in the ordinance. But we can't unring that bell. So any additional comments or discussion? Is there a motion to either approve or deny the appeal? Hearing none, I'll make the motion. I'll make a motion to deny the appeal. Is there a second to that?
I'll second it.
Motion been made and seconded to deny the appeal. Any discussion on the appeal or on the motion? Okay, all those in favor of the motion signify by saying aye.
Aye.
So 3. Okay. So
I'm gonna do a roll call.
yeah, we'll do a roll call ballot. Dee,
Aye.
Jim,
Aye.
Steve,
No.
Gordon,
Aye.
and Al. Aye. The motion to deny the appeal passes by a vote of 4 to 1. Findings of fact. I believe the zoning administrator and the zoning committee followed the letter of the law as it appears in our Sawyer County Ordinance and Shoreline Ordinance guidelines. Okay.
Done on that one?
Yep, done with that one. Thank you all for appearing. Yeah.
That's me.
I'll get up.
You're not leaving, are you?
No, she's taking-
Oh,
She's
okay.
taking- she was on the first.
Okay.
How are we doing this?
Yeah.
You're the one that-
He was in on the first.
I did.
So, yep, you're right here.
Look at it. You can take mine. Go.
Yes, there it is.
I think so. Guys got up, people got up and left, so yeah. Yeah, for the record, we are adjourned for a 5-minute break. Is there a special procedure? Are we live here?
Yeah, and I guess I'll reread the variance application, back.
Do we need to call the meeting back to order? or
Oh,
something?
sure, yep.
Okay, how do you do that? Say the meeting's called back to order?
Yep.
Okay, all right.
All right, second is the variance application, a public hearing in the town of Bass Lake, variance number 22-001, with a stipulation in order to remand for reconsideration consistent with applicable law. Owner Dean and Heidi Miller, part of Government Lot 4, Lot 3, CSM 12/357, Section 6, Township 39 North, Range 8 West, parcel 002-839-065404.26 total acres, zone residential recreational 1. Application is requested for 3 specific elements of an after-the-fact variance request. One is the construction of a patio walkway area that is outside of the existing cantilevered portion. This would be viewed as a 1 foot by 21 foot expansion area of the patio and wing wall closer to the water. The second element of the request has 2 specific expansions related to the same area. First is the relocation of an existing retaining wall not within the existing footprint. The existing retaining wall was relocated further from the water. The second specific request is moving the retaining wall further back. A smaller portion of walkway area was added. The approximate size of the walkway expansion was an 11 foot by 4 foot triangular portion. Number 3 is the expansion of the walkway area of approximately 1.5 by 5 feet. There was an existing walkway which was allowed for replacement and expansion of the patio area underneath the cantilevered portion. However, there was a small gap where there wasn't existing walkway area, which has now expanded. All of these setbacks to be measured at 1 foot to the ordinary high water mark of Lac at the closest point. All other setbacks would be met. Variance is requested as all the variance elements would be subject to section 6.1 of the shoreland setbacks of the Sawyer County zoning shoreland wetland protection ordinance, which would require the prior granting of a variance for any new structures not within the existing footprint of the existing structures closer than 75 feet. This proposed request is an after the fact variance for a 1 foot shoreline setback from the elements previously described. The board got all of the requested information. You have the packets from the last time. You've hopefully had a time to read the transcripts that were also provided in that, as well as the remanding back for reconsideration by a circuit court judge. That is what I have as far as to read into record. And I guess it's up to the chairman and corporation counsel is if you're wanting to take new or additional testimony, or whether or not you're wanting a summary of previous events from the applicant or those in opposition. And I'll defer to corporation counsel and the chairperson for that.
Well, I just set the record that following the last hearing, there was a writ of certiorari filed on behalf of COLA. That was set before the circuit court in Sawyer County. The plaintiffs in that situation, COLA and Sawyer County Board of Appeals, through me, came to a stipulation where the parties agreed that the findings made by the Board of Appeals in the last hearing did not meet the standards that were required. And the 2 parties agreed to remand, and the court agreed to remand it back to the board to make proper findings and to make them based on the law and the ordinances. So I think for today's hearing, and one of the things I would note is that one of the board members has been changed. Was it Mark Olson was?
Yeah, so we should reference that Mark Olson was previously on this board and no longer is. We do have, and maybe it's proper at this time to state it for record, as far as that Laura Rusk is now back on this board as not a recusal, but as a full member, and that a previously appointed board member, Jim Tiffany, did not get the pertinent information to this, and that he was appointed just last week. And I had already set up for our first alternate, Gordy Christians, to read through the existing transcripts and the case file information. So I just wanted to let the record reflect that.
And I advised him that he could not participate unless he had read through all the transcripts, all the materials that were submitted at the last hearing. And my understanding is that he has, and I would ask the chair to ask that and confirm that he has reviewed all the information and is able to sit and assist in making the decision tonight.
Okay, Gordon, did you have an opportunity to read through the literature that was provided? And do you feel, I guess that's a simple yes or no.
Yes.
Okay, do you feel the need to hear additional testimony based on what you've already read?
I don't think so, no.
Okay.
And you read the entire transcript? I did.
Okay.
So I think today is the time set for the board to make a decision with proper findings. I don't think unless the chair decides to take additional evidence, which I think all the evidence has been presented. And I think that's your call, but I think you guys can move to make a decision with proper findings.
All right, this is my first rehearing. Do we need to read into record what the original decision was, the motion?
No, your original motion, no.
Okay.
It's been remanded. I mean, if you wanted to hear what the town said, that's one thing you could do, but it's all in the documents and all in the packets that everybody's got. So I think unless someone needs that read into the record, I think.
I'll ask that question. Yep. Okay, the board members now seated. Do you need to rehear the motion that was voted on when this variance was originally heard on, I believe, July 22nd? Does that sound right?
July 20th.
July 20th of 2021. Does any board member need to rehear the motion?
And I think when it's remanded back, I mean, you can make the same motion, you can make different motions. I mean, I don't think you're bound to do the same thing. I think the committee can discuss it and a motion can be made and seconded and hopefully approved, and then proper findings can be made for that.
Okay. Based on
We said it does have the information from the town if somebody wanted it, but I think it's a new packet.
okay. Just to make sure that we're all voting on the same motion, I'm going to request a motion to either approve or deny the variance request that was made by the applicant. Is there a motion to approve or deny the variance request that was made by the applicant?
And I mean, it can be discussed, but there was, I think as Jay mentioned at the last hearing, there were 3 elements of it. And whether someone wants to address all the elements in one motion or, and I think that was done the last time. I think there was 2 different motions made, one failed, the other one didn't. But I think Jay, if you want to briefly, I think you touched on those 3 different elements, correct?
I did, and I do have the transcript of, the previous motion, if you want me to read that.
If you would, please.
Al Gerber, I'm going to make a motion to approve the variance as presented. Second, D. Dublis. There's a motion and a second. There's Al Gerber. There's a motion and a second. Discussion on the motion. I don't think we're setting any type of precedent here. Steve Kelsey. I will say the reason I'll go along with the variance is because of the point made that I think tearing out and changing that may be more detrimental to the shoreline than what we have right now. Mark Olson. How they get all that old concrete out of there, you take a concrete saw, you cut 1 foot line all the way down and you cut. Steve Kelsey, that's 5 feet, that's 5 feet deep, 1 foot thick. Mark Olson, yeah, you take out 1 foot, and that is all. Concrete by hand in buckets. Al Gerber, someone might make that argument. Now everybody's going to do this. They'll just overbuild and come back and say if we do more harm, then they'll take it out again. And I don't think that argument would hold water. Mark Olson, well, I'd go back to the old boys network years and years ago on zoning. It was who you knew and who it got passed, and people cut all the trees down on the shoreline. They got a $500 fine, and they had a lake view that lasted them forever. You got to replant trees so that plant saplings have to take 30 years to grow, and you're dead and buried. But I mean, there's a lot that went back when you first got involved in zoning, in my opinion. Al Gerber, I don't agree that scenario exists. All those in favor, leaving the variance requested intact as presented, signify by saying aye. D. Dubus, aye. Al Gerber, aye. Steve Kelsey was an aye. All those opposed, Mark Olson, Laura Rusk. 2 opposed, let the record reflect that the variance was approved by a motion of 3-2. Findings of fact. There is no change in the use of the zone district. It is not harmful to the right of others. It is not detrimental to the health and community of the lake. Mark Olson, I would ask just because you know it'll happen, you maybe expand on those 3 reasons. Al Gerber, no. Mark Olson, yeah. No, if somebody wants to question it, they can. Mark Olson, okay. Al Gerber, all right. Is there any other new business? That is all.
So one of the things that I would suggest is that if the same motion is going to be made, there should be some discussion about the 3-step process and how the person making the motion feels that it fits within that 3-step and it applies with the ordinance and the state statutes. I know you can do findings afterwards, but I think there should be some discussion amongst the board before any motion is made as to how we think it complies and how we think, there's unnecessary hardship. I mean, those elements have to be addressed. And I know you can do them in findings, but I think discussing them some in advance would be a appropriate thing to do.
Okay. Part of this 3-step test that we try to apply to each variance request asks if there are conditions that are unique to the property. And in this case, I believe that there are. The property is very small in size. I believe it's only 70 feet or less on the front and less than 40 feet in the back. That lot size creates a very unique property limitation. Another unique property limitation or character on this site is that is the proximity of the existing dwelling to the shoreline. As far as harm to public interest, the evidence that was presented showed 0 impact to any of the neighbors' properties, nor any negative impact to the aquatic species or plants or habitat. One of the positive effects of the proposed dwelling there is that rain gutters have been installed in rain gardens. There is virtually no runoff now going towards the lake where there had been previously with the old structure. And the statement that Steve had made earlier about cutting away a 5-foot retaining wall would be very, in my opinion, in my judgment, would be very detrimental to the lake with the possibility of pollution going into the water and taking that retaining wall out. Leaving it there does a lot less harm than, well, actually, I don't think it does any harm at all, but taking it out certainly creates a potential for debris to fall into beyond the ordinary high water mark of Lake Courtrai. Rebuilding in an existing footprint is a permitted use. A hardship would be created if no rebuild was allowed. There had been some discussion in the previous testimony that this was a boathouse that was being turned into a dwelling, and I don't recall hearing any testimony that that showed that the most recent use was a boathouse or the former use of the boathouse. There's one of the old pictures we saw showed a sliding glass patio door facing the lake at near the lake level, but certainly no boat could have got in or out of there. Any further discussion? Hearing none, I'll make a motion to permit the variance request as permitted. All three of the requested changes, if changes is the right term. Pardon?
Elements of the request.
Elements of the request.
Will we have opportunity for additional discussion after the motion is made and seconded?
Yep.
Okay.
So there's a motion has been made. Is there a second to the motion?
I'll second.
Second by D. Douglas. Okay. Discussion on the motion.
Now here's my discussion. It's already, everybody read it last time. It's in the transcript and it's the same discussion. I think, and I am a stickler on it because that's how we're supposed to look at these after the fact variances, which it indeed is. And I know there were extenuating circumstances in this instance. There certainly were. But looking at it, I feel that what Mark had put forth last time was a reasonable solution, which solved the majority of the problems. And again, the question is, if this had come to us asking for a variance to do just exactly what was done, we would have said no, that won't fly. So I remain the same as I was last time.
Laura, do you think that taking it out solves anything? I mean,
but that's
maybe
not our job, Al. That's not the way I look at our job.
Okay,
And state
I respect that.
statutes don't say mull it over in your mind, and if you think it would be any worse or any better, they tell us that we are to look at a after the fact variance as if it had not happened yet, and what would your decision be? And that's how I feel. I cannot change that because I think that's what we're supposed to do. And I also don't think that cutting off a portion of it would cause any detriment to the lake either. I mean, it's solid concrete, and if it got cut, it's not going to be a major problem for the lake. But that obviously is not the wishes of the board. So,
well, it may be the wishes of the board, but as I don't share the same opinion.
I know.
Okay. Okay. Any other discussion?
If I think there's some dispute as to whether Laura thinks that there's no harm in cutting the 1 foot off to do what the motion that Mark was.
that's not really my whole
Okay.
point. Though.
I just want to zero in on that. So what your position is and what Al's is maybe in response to that.
Okay.
No, I say give your position again. I don't want to tell them what your position is.
My comment about whether or not it would be detrimental to the lake to cut off a 1 foot by however many feet section is not my main reason for saying no. It's that a solution was offered, and we are to look at after the fact variances as if they never actually happened. If they came to us and they said, this is what we want to do, we would, and Al agreed, we would say, well, no, you can't do that. And so that is how we're supposed to react to that, and the way I believe we're supposed to react to it. So my position isn't so much about the adverse effect of cutting off the one foot. It's that I'm looking at it as an after the fact variance that we would not have granted.
If you want to respond to that to the rest of the
No,
committee.
I understand Laura's position completely. Don't necessarily agree with it, but because as you stated, Laura, there are many other circumstances that got us to this point.
Correct.
You know, the whole footprint deal and the approval of the plans and all of that. So,
and I don't know, one thing I would mention is that if other members have something to say, I mean,
for sure.
You should chime in before the vote is taken versus after. I mean, so if you have some concerns about what the motion is or not. I mean, I think that now is the time to put in your 2 cents worth.
Well, I guess my cent worth is. I can see the point of putting the cement there. I looked at the aspect of the lake there and the ice heave there must be pretty severe. And some years, not every year. So you're gonna get, I think eventually, even with the cement that they poured, you're gonna get an ice heave there anyway. You're gonna get it blown out eventually. Just because it piles up there. But in the meantime, I guess I would go along with Mark's motion, we're taking 1 foot off and the rest would be okay. As a partial way to meet the requirements of what we're at. Getting it under the footprint. No, I don't know how deep the footing is right there where they have to dig down into the soil to replace the footing. You can't really see that now.
I think do you know how deep that is?
I believe there was previous testimony from Jeremy Hill that it was 5 feet,
5 foot
5 foot thick.
down.
Yeah,
Yeah.
5 foot from top to
Oh, yeah,
bottom.
yeah, the top, but what about
No, 5 foot
underneath
from
the
top,
outside edge that you'd be sawing off,
5 foot from top to bottom,
top to bottom?
Yeah.
So you had a 5 foot
slab
Foot.
1 foot thick.
underneath.
I don't know if you
Not
came,
this horizontal part, the vertical parts I'm looking at.
That's 5 foot,
I don't know,
5 foot thick
And
and
you
5 feet
may-
wide.
if you want to hear that as additional testimony, you certainly could, but I don't believe this plan called for footings that came down and out. It was just down. So that slab there as part of the footing is 5 feet down.
Oh, okay, well, that's different.
5 feet below grade.
No, from the top to the bottom of that, it's
All right,
5 foot.
All right, and there's
It's a 5 foot
There's-
lip there,
a difference.
and it's 5 foot thick, but it's 5 foot lip.
That's different.
Yeah.
In which case I would go on.
Any additional questions or comments? Okay, I'm going to call for a vote on the motion as presented. All those in favor of the motion as presented signify by saying aye. Aye. We'll do a roll call. Dee,
Aye.
Laura,
Nay.
Steve,
Aye.
Gordon,
Aye.
and Al, aye. Motion to allow the variance as, all 3 elements of the variance as presented passes by a vote of 4 to 1. The findings of fact are the same as,
Well, I
pardon?
think you can do them again.
You previously discussed them. It's part of your
Okay.
making
You
of the
discuss them, but I
motion.
think you can make them again
Okay.
and more specific if you want.
Findings of fact, there are conditions that are unique to the property. There is no harm to public interest. And a hardship would exist if a rebuild was not allowed. Okay, that's that. Any additional business before the board?
I did get a transcript email from the DNR as far as the BoA is requesting in writing from the BoA, but the DNR is requesting in writing from the BoA that whether or not you want the DNR to render an opinion for shoreline zoning matters. You had previously done this, and I think they're looking back in their records and wanting it just to be updated. You'd probably done this back when the shoreline zoning standards changed 6.5 years ago. And you submitted at writing at that point that yes, you wanted to hear from the DNR on matters that regarded shoreline zoning. They're wanting you to put that in writing again, as that some state statutes have changed, and they're wanting to update that process. Whether this should come as an official agenda item, I don't know, because you've already stated that, yes, you want the DNR's opinion. It is not as an action item because it wasn't listed. If you want, I can bring it as an action item to make everything as a smooth process in June. But in the short time, because you've requested that DNR's input 7 years ago, for the June cases that we'll have, I'll still submit it out for them. But just to give you a heads up, next June or this coming June, you'll have an agenda item that is going to basically request something in writing from the BoA that you want DNR opinions. If you don't want DNR opinions, you don't have to have them. But if you do want them, they want something in writing.
I think that we should have them involved on the front end rather than after the fact.
But I will list them as a discussion action item for June.
Okay. Any other business before the board?
Mark Olson, town of Bass Lake resident. This may seem out of place, but any way you can request that the two people that made the last one we ever heard from the DNR never give us another one? If you go back in the record, I think it was two girls from third grade that gave us the
I
recommendation.
recall that one.
Oh.
Yeah.
Mark, I doubt that we have the authority to specifically request or deny. All right, is there a motion to adjourn?
I make a motion to adjourn.
Your second, third, fourth, all those in favor of the motion, signify by saying aye. Aye.
Mine.
No.